Next is in the matter of East Bay Drywall versus the New Jersey Department of Labor. Counsel could please step forward. May we please have appearances of counsel?
Christopher J. Hamner, Deputy Attorney General, on behalf of the New Jersey Department of Labor and Workforce Development.
Good morning, Chief Justice. Ravi Sadaraju of Sadaraju and Tharney, on behalf of amicus, the National Employment Lawyers Association in New Jersey.
May it please the court, Jennifer Barr with Cooper Levinson on behalf of the respondent, East Bay Drywall.
Good morning, Your Honors. Jeffrey Jacobson, Fagery Drinker, on behalf of amicus, New Jersey Civil Justice Institute.
Welcome, counsel. Please be seated, everyone. Mr. Hamner, please go ahead.
Good morning. May it please the court. If I could reserve 4 minutes again for rebuttal, that would be, if necessary, may I? May it please the court, the appellate division erred in its application of prongs C and B of the ABC test in reversing the commissioner's finding that the drywall installers for East Bay were not independent contractors. Indeed, in misapplying prong C of the ABC test, the appellate division ignored years-long precedent established by this court, leaving the state, employers, and workers with conflicting judicial guidance. It is important to remember that the employer bears the burden of establishing that the workers are, in fact, legitimately independent contractors for purposes of prong C. This is done by an examination of the factors commonly associated with a business to determine whether a worker actually has an ongoing business concern that is stable and lasting and can survive the end of the immediate relationship. Here, some of the workers presented insurance certificates to East Bay to demonstrate their independent business status and nothing else. The department attempted to ascertain additional evidence they were legitimate businesses, but could not. The court found that possession of such insurance certificates were significant but not dispositive indicia of independent business status, but then found that it was sufficient, despite the lack of any other evidence. In doing so, the appellate division, for all intents and purposes, held that a worker who simply forms a single-member business entity and possesses a certificate of insurance can automatically establish independent contractor status. This holding flies in the face of corporate remnant. It's an easy matter to buy insurance, even for a non-existent business enterprise. The court incorrectly lowered the threshold of factors needed to establish independent contractor status. The court indicated it did not want to endorse the use of sham corporations or LLCs to avoid UCL contributions, but that is exactly the effect this ruling will have. The commissioner specifically addressed 2 alleged companies as representative samples, and the rest were exactly the same as to the relevant characteristics. The court agreed as to these 2 workers, but reversed as to the rest, because they were not, each was not individually discussed in detail. This was error, as none had any other evidence of business status aside from the insurance certificates. The court misstated this as a gap in the analysis and as a conflict with the ALJ's fact-finding, but it was not. The commissioner made no new findings of fact. He merely ruled that the ALJ erroneously applied the facts to the Prong C analysis. As to Prong B, this factor requires that the employer demonstrate that the workers perform services either outside the usual course of the business for which such service is performed, or that such service is outside all of the places of business of the enterprise for which such service is performed. This court has defined the phrase all places of business to include not only where the company maintains a physical location, but also where it conducts an integral part of its business. It's undisputed that East Bay's business is the installation of drywall. The court erroneously applied the places of business analysis in corporate remnant, finding that the places where drywall were installed or outside of all other places of East Bay's business. Carpet Remnant's core business was selling carpet. East Bay's core business is the installation of drywall. That installation necessarily takes place at building sites, and nothing in the record indicates that East Bay even maintained a physical location. Applying the finding in Carpet Remnant as if the facts are in any way similar is clear error. Misclassification of workers as independent contractors frustrates the remedial purpose of the UCL by not only adversely affecting the Employment Trust Fund, but most importantly, rendering the misclassified workers ineligible for unemployment and disability benefits.
Are you concluded with your opening
I
statement?
have.
In a case like this, should the factors in Carpet Remnant be considered?
They should. They should.
Was that done here?
I'm sorry?
Was that done here?
It was not done here. It was not done here by the appellate division. The appellate division was satisfied that they had insurance certificates. That is not necessarily characteristic of an ongoing legitimate business. This harkens back to the
Was it done at the agency level or by the ALJ?
It was in the OAL, the auditor testified as to the lack of any other business indicia. In fact, the auditor went above and beyond. It is the employer's burden to establish these things. East Bay did not establish any other factors such as how much these alleged companies earn outside, whether they have other contracts, whether they have their own employees. There was no comparison or any indication that they earned money anywhere else. And there's nothing to indicate that there would have been an ongoing business concern. Look at in Gilchrist in 1957, this court said one of the key factors is whether a purported business can survive beyond the immediate relationship. And none of that evidence is here.
Should this court state that the Carpet Remnant factors are to be considered in these sorts of cases going forward?
They should be considered. Yes, this court should consider the carpet remnant factors. It's not an exhaustive list. Carpet remnant factors are there that demonstrate what is characteristic of a legitimate ongoing business.
So let's take that for a second. 'Cause I'm trying to think of the burden on the employer. In this case, the auditor found that half of the people working on these drywalls were independent contractors. And then it concentrated on the 16 that are before us, correct?
Correct.
So I'm looking at the C factors in carpet remnant, like duration and strength of each subcontractor's business, the number of his customers, the number of his employees, the extent of its resources. And then you also said whether or not it's going to be able to exist, after its employment with East Bay. I'm trying to figure out, like, how is an employer supposed to know that in advance? It may have like dozens of subcontractors. We know that 16 were considered independent. Like, what sort of examination is the employer supposed to do in order to figure out whether or not the subcontractor, which is, let's say, an LLC, is going to survive after it's done a couple of drywall projects for East Bay?
Well,
You following me?
well, that would be something, it's the contract, it's the employer's burden to ask. It's the employer's burden to investigate this before they decide how they're going to treat a particular worker. In this case, the owner said, yeah, I checked for insurance certificates and I was satisfied with that. Nothing else.
I know, but one of the factors, and you mentioned it, was are they going to have like a business after East Bay? And let's say they're LLC. Like, what is the employer supposed to do? And I'm trying to figure out if they've got 20 different subs. Are they supposed to interrogate them? Tell me, what is their obligation?
Well, first, we don't concede they're subs. They're just workers. They hired them to do this particular job. the employer here was familiar with, it's all word of mouth within the industry, within the construction industry. You called other contractors, have you used this person, have you used that person? Do you know someone who can work for me, who I can hire for this particular project? It is the employer's burden. That's how the legislature has structured this statute.
No, I understand that it's the employer's burden. It's clear. But I'm trying to figure out, like, how much, like, what is that burden? And that's why I was asking that question. Is, in terms of, like, how far are they supposed to interrogate the person who may be coming with some sort of corporate clothing, like an LLC?
The employer's responsibility to determine whether this person actually has a business. How they do that, who they ask, what they check into, that's not something that can be spelled out specifically by the court.
At the end of the year, the employer would know if this individual worked for 10 weeks or for 45 weeks, which could inform the decision, no?
Perhaps. It's difficult to say. Different industries may work in different ways. A particular worker maybe work for them for 45 weeks and for someone else for 15 weeks or anything. Unemployment contributions, I mean, unemployment benefits are based upon base weeks of employment. It doesn't have to be with the same employer. It can be with several employers. And in the aggregate, whether they're responsible or whether they're eligible for benefits based upon total weeks of employment within a particular period of time.
Did East Bay have a physical site? Do we know whether they had a building, a lot, equipment?
The record doesn't contain any information that they had a physical location.
How do courts apply Prong B in the era that we're in today, where much work can be done remotely and where there may not even be a physical site for administrative work in a business of this kind?
The Department of Labor recognizes that, but this is the way the statute is written. Whether to modify the statute to account for such situations would be a policy decision on the part of the legislature. It's their role to modify it or add exceptions as needed, and they have not done so.
So the statute is what it is, as you point out. How does the department recognize it, and what does it do in this situation?
Well, like in this situation, they looked at what the core business is. What does East Bay do? They install drywall. Where does that take place? It takes place at construction sites. It takes place in these residences.
Yeah, at least in Carpet Remnant, there was a warehouse and also retail stores. Go ahead.
Yes, Carpet Remnant Warehouse had 2 retail locations.
Yeah, so I'm trying to figure out, in this case, should there have been established on the record what physical site East Bay had?
There's nothing in the record that indicate that they even had a physical location at all.
So that would seem to be problematic for purposes of the analysis.
Not at all.
I guess your argument is they'd have to show that. The burden is on them. And if they're not showing that, then the place of business is at each drywall construction site.
Where the bulk, the core of the integral part of their business, where that takes place.
Okay.
And that's
Did they
what-
provide
that's
an
what Carpet
address?
Remnant-
Did they provide the department with a business address?
I don't believe so. And I want to note, I'm glad you brought that up, Justice, because as far as business addresses, telephone numbers, internet presence, none of these workers had that either.
I'm talking about the workers, the East Bay. Did they, on forms that they filled out, was there an address?
I don't think that's in the record.
So your position is, second part of B, that such service is performed outside of all the places of business of the enterprise. They haven't established that they have any place outside of each construction site.
Right, right. And this court said in Carpet Remnant that means where an integral part of their business takes place.
Let's assume that's true, that they don't have a business site and that every location where they're doing drywall is a place of business for them. that's only one of the factors, correct?
In the B prong.
In B, that's one of
B
the.
prong is disjunctive. One can either, either or. There are two choices in the B prong.
So let's assume that's the case. That means B is out of the picture, they're employees. No, not necessarily employees, right? You still have to go to C.
I'm sorry, Your Honor?
You'd still have to do a C analysis, correct?
Yes. They must meet each and every part of that ABC test.
Okay, so with respect to C, coming back to what Justice Albin said, if all they have is the information that they needed to write a check at the end of every week for these individuals, how are they supposed to show that they were going concerns, that they were doing work for others? If all the information they had was enough to fill out the 1099, what are they supposed to show and how are they supposed to show it? And, I guess, lastly, is what they showed enough here if that's all that exists?
What they showed was not enough. All they have were insurance certificates, and the
So
owner
even
of
if
East
there's,
Bay,
I'm sorry.
I'm sorry, go ahead.
No, finish, please.
The owner of East Bay said he checked. He asked them for insurance certificates. I mean, the concern is that this would lead to abuse. There's nothing preventing, with this holding, there's nothing preventing an employer from saying, I'll hire you, but first you have to go online, spend a few dollars, become an LLC, and buy an insurance certificate, then I'll hire you.
So essentially, the fact that they could ask them if they had an insurance certificate and provide that, but did not ask and cannot provide anything other than that, is on its face insufficient.
Yes.
Tell me if I'm mistaken. I want to be clear about this. The employer has the burden of establishing all three prongs, A, B, and C?
Yes.
So if it failed in B, it's over. They're employees. You don't go to C then.
That is correct.
Okay.
That's how the statute is structured. And I do want to note that this is not new. The ABC test, current iteration of the ABC test is word for word identical to that of Chapter 312 of the laws of 1938. So this is not something that's, suddenly sprung upon the state or sprung upon the world, or employers wouldn't know this.
So if, this is hypothetically, if the work site were the construction site, that's the only site,
Yes,
they're employees from your perspective.
yes,
Don't look at A, don't look at C.
that's correct. Whether that should be modified is up to the legislature, and it hasn't.
Do regulations govern any of this?
Well, the regulations derive from the statute.
Right, but I mean, the statute's pretty bare bones in terms of such
is.
service is performed outside of all the places of business of the enterprise for which such service is performed. Do regulations drill into that, as sometimes they do?
There aren't any present regulations that address the ABC test.
The reason I say that is because you're saying the legislature would be the one to respond to current conditions where perhaps businesses don't have offices so often in the traditional sense. But this is a very skeleton kind of statute. I'm just wondering if perhaps the place to do that might be in a regulation.
Well, there presently aren't any
There are
regulations.
no regulations.
I want to follow up on your answer to Justice Albin's question. If the work site is the place of business, you can't prevail under B, and therefore you're an employee,
It is
correct?
possible that you can't prevail, correct?
So that would then sweep in an individual who did 1 or 2 or 3 installations over the course of 365 days and derived most of that individual's income from jobs for others. That person would be considered an employee under your analysis?
For this particular project, for this particular company, yes.
For this company?
Yes.
And just so that I understand, even if it's a very small fraction of their overall income and of their overall work, they would still be an employee of East Bay.
That's correct.
It would also mean that the Department of Labor erred in its determination that the 16 other companies, other half, were independent. They should have been all designated as employees.
Not necessarily. We don't know the facts. We don't know who they are. We don't know that, because they were not in dispute, those facts were not brought forward in the OAL.
But they'd be working at the locations, and you're saying that that's the ball game. If they're working at the locations and there is no place of business on the record.
We don't know what they were doing. Perhaps East Bay needed an electrician for some reason. We don't know what they were doing. Those facts weren't developed. They weren't in dispute.
Did the Department of Labor look at those LLCs and
The
individuals?
initial auditor, well, we don't know if they were LLCs. We don't know anything about them. The auditor looked at this, found that several of them were in fact independent businesses. We don't know what business they were in. We don't know what they did on-site, off-site. We have no information about it because they were not in dispute.
Let me follow up on some of the questioning about the Prong B issue that you raised. Let's say there's an LLC that has 30 employees and sends them out to different jobs, okay? They send them out to East Bay's job on Maple Street, somebody's house. East Bay doesn't have an office. It works only at the locations where they've been asked to install drywall. Are those employees of that LLC that has 30 employees that it's dispatching to these different jobs employees of East Bay simply because they're working in the home?
It's a fact-specific inquiry. If one of these
Understand, but what you're asking us to rule is that it's the ball game as soon as it's established that they're working in these homes.
With this set of facts, if East Bay wasn't in the installation business, say East Bay was a general contractor, and they hired another company like East Bay, who had employees, and they have 30 employees and 3 are on the.
Use these facts. Okay, you're saying and my hypothetical would be a drywall installation company, which doesn't have the staffing to get the job done, hires from someone who has 30 employees, pays that company for their time, and you would say that they become employees for purposes of the UCL because they're working in the homes that are in fact the place of business of East Bay. Is that what your position would be?
It's possible for a worker to be an employee somewhere, but for East Bay, they're an employee for purposes of this, using these facts.
So the worker could be getting unemployment through the LLC that in my hypothetical with 30 employees, and then the UCL is also triggered because they go out for 2 weeks and work in a house and install the drywall, or I don't know how long it takes.
Well, these
3 days.
These workers were paid directly.
No, I understand, but do you see what I'm saying? Is that by saying, by
I think the facts are not the same. I think that if they're paid directly by East Bay, they're working for East Bay.
So,
Even
but
though they may be employed somewhere else.
Are you asking this court, and because this obviously affects small businesses, potentially, in a very competitive market, are you asking this court to find that for purposes of Prong B, if there is no office, and the locations where the small business operates are in those residential locations, that whatever happens in terms of their bringing somebody in, they're paying the unemployment?
If they are paying a worker directly, and they have no physical location, and the integral part of their business takes place at a remote site, then those working at that remote site who are paid directly by East Bay shall be considered employees.
So is there a distinction between them, between them paying an LLC that has a bunch of employees and them paying an LLC that consists of one person?
A single person LLC is an entity separate from the individual. I mean, it's not separate from the individual. It's an individual. It's paid as an individual. Well, if there's nothing to stop a company from hiring another company, having contract with that company, paying that company billing East Bay and paying that company to provide workers.
I don't see the distinction, frankly, and tell me what I'm missing here, between, let's say an LLC has 2 members, and one member goes out to one employee who's a member of that LLC goes out to do the work, and the other person's on another job. And you would say that they're going to that residential location, and that's all B is they can't satisfy as soon as they're working there, whether that's a 2-member LLC or a 1-member LLC or perhaps more. What would, under your analysis, that's the location is the end of it?
The location, that's where they conduct an integral part of their business. If they're paying this worker directly, that's an employee under this analysis, under this set of facts and this particular statute.
Okay, and that's true if there's a 2-member LLC.
If one is paid directly by East Bay, yeah.
So how about we go to 10? How about if there are 10 employees to that LLC? The LLC gets paid for their time. The members of the LLC share in that.
The LLC gets paid directly?
The LLC,
Well, that would be a subcontract.
well, these people are LLCs.
Oh, they're single-member LLCs. They're single-member LLCs, and they were paid directly by East Bay. They were issued 1099s. They weren't issued, they weren't paid as a business. They were issued 1099s.
Is it your position, I'm trying to understand it in response to the questions and answers between you and Justice Patterson, that the corporate status is immaterial provided that the worker is paid directly by East Bay? I'll call East Bay the general contractor. Is that your position? So it would make a difference if it's a 1-person LLC or 10 people are in it. If the worker is paid directly by East Bay, that's the way the analysis goes, and the corporate barrier is immaterial. Is that your position?
For a single person LLC, they're being paid as a single person. Right now, there's no indication that East Bay subcontracted with anybody. We don't know if the others that were considered independent businesses, we don't know their status. That record wasn't developed. Here we have particular individuals working on particular projects, and they are paid directly by East Bay. I would like to note that for a couple of them, prior to 2013, they treated them as employees and paid them with a W-2 rather than a 1099. And there was no articulation of why that changed by the time of the audit.
Counsel, can I ask you, is part of your argument based on the appellate division's application of the standard that to be applied to decisions of administrative agencies in the area of expertise that they have, that the appellate division did not properly apply that standard of review?
That's correct. The agency is owed some deference, especially in this situation.
I'm sorry, if you could pick up your voice a little bit.
I said the agency is owed some deference, especially when they're talking about the areas within their purview, as here. One of the major errors that the appellate division said, just because the commissioner did not list each and every single one that they didn't find in his favor, even though the 2 that they agreed with have the same exact characteristics and no more indicia of an independent ongoing business as any of the others. It begs the question of what is the commissioner supposed to do if there's 100? Is he supposed to list each and every one and say, number 2, same as number 1, number 3, the same? It appears that the appellate division, the only reason when they agreed with 2, and they have the same characteristics as the others, the same relevant characteristics, it's error to find that the rest of them don't also fall within the commissioner's decision. That they just found that they met Prong C only because the commissioner didn't list them. But the commissioner specifically said they have the same characteristics. Not one of them has any more indicators of being an independent business than the 2 that the court agreed with.
What did the commissioner find on B?
On B?
Yep.
The commissioner found that the places of business are where the construction actually takes place.
We're not, so they found that the employer had satisfied B or not satisfied?
Did not satisfy B.
So the commissioner found that neither B nor C was satisfied.
Going to the commissioner's decision, it described the under Part A, what the commissioner found were the activities for East Bay. And it says that, as observed by respondent, the testimony of Benjamin Descala, a managing member of East Bay, reveals that East Bay bid on, negotiated for, and acquired all of the work performed for the drywall subcontractors. The amount paid by East Bay to the drywall subcontractors was a fixed amount set by East Bay and not negotiated with the drywall subcontractor. East Bay provided all the materials for the job, such as sheetrock, screws, nails, corner bead, spackle, level lines. In other words, the people that were doing the actual work at the work site were performing as employees of East Bay in all respects, because they were given the materials and they were asked to perform the work needed to make those materials to carry out the contractual obligation that East Bay had with the GC, with the general contractor. Am I correct on that?
Yes, because they had the workers had no connection whatsoever with the builder. Any complaints went to East Bay. East Bay told them what they had to do. And
by considering these people subcontractors, that avoids East Bay from having to pay unemployment compensation insurance.
not only that is correct. And not only that, these workers would later on be ineligible for unemployment and disability insurance.
Because they're considered subcontractors,
Correct.
not employees.
Correct.
And that undermines precisely what the public policy behind the statute.
It frustrates the remedial nature of the unemployment compensation law, and that's the problem with misclassification today, and it's a large issue for the Department of Labor. This enables an employer to shirk their responsibilities to provide their payments for disability and unemployment insurance. So the question is, the problem is not only how it affects the fund, but more importantly, how it affects the worker later on, making them ineligible for these benefits.
And so the presumption is, under the law, you're an employee, and the employer has to prove otherwise.
Yes.
Anything you'd like to add to your presentation?
No, Your Honor. I just want to reserve time later for rebuttal if necessary.
Yeah. Fine. Mr. Satarajan, please.
Chief Justice, Justices, thank you very much. On behalf of the National Employment Lawyers Association of New Jersey, it's an honor to appear before you, and we're very grateful for the opportunity. This issue of worker misclassification is a very serious issue in New Jersey and across the country. In our papers, we cited Governor Murphy's 2019 report. While this case involves the unemployment, the UCL, this misclassification test is the same for the wage payment law and the New Jersey wage and hour law. And the result of this case could have dramatic impact for tens of thousands of workers who could be stripped of their rights under these statutes. The wage and hour law and the wage payment law are remedial statutes that must be interpreted liberally in order to achieve their purpose. When we're talking about whether someone is an independent contractor, the question we're really asking is, do they receive the benefits of the wage and hour law and the wage payment law? That means, do they get overtime after they work 40 hours a week? That means, are they subject to illegal deductions from their pay? For example, can they be made to pay for their own equipment? Can they be made to pay for any damage that happens? And these are all protections where the answer would be no if they were employees. Once they lose those protections, because they're quote unquote independent contractors, they don't have any of those protections. So
Give us a scenario in which, and knowing as you do, I assume you're familiar with, just based on this record, with East Bay's business model, which is installation of drywall in residences. How could East Bay set that business model up to ensure that it was working only with independent contractors?
Well, what I'll say is, if you look at the definition of to employ under the wage and hour law, The definition of employee is to suffer or permit work. That's a very broad, and when this court addressed the Hargrove case, it noted that was the broadest definition that you could have under the law. So right now, when East Bay brings in people to do drywall, they're suffering or permitting work. People are working for them.
So do I interpret from your answer that there is no way that this business model where they get people to install, somehow procure employees qualified and skilled in installation of drywall, and those people do the work, that can't be done other than through employment?
What I would say is that if they meet the standard under the ABC test, which is purposely a high standard, then they may
We're going in circles at this point. How would, because you obviously have a lot of expertise in this area, how could someone, a small business that wants to install drywall but doesn't have 25 employees in their, who they hire as full-time employees, and is responding to the need for the jobs that come and go, and in a construction business that obviously has ups and downs, are you saying they cannot do that business without having everybody who comes and works for them for 2 weeks or 3 weeks be considered employees?
Well, if I could answer your question, because I see the practical element of how this works. If someone comes in for a day and you're not, I think the concern is, well, if these people aren't working full time and they're only working 1 day a week or 2 days a week, or they're working 3 days in 1 month and a week in another month, there's nothing wrong with getting the paperwork for those people for that period of time, saying, all right, you're employed. If they're calling in an agency or they're calling into a shop saying, we need workers for this day, it's easy to say that, all right, for that period, you'll be working. And then what happens is you are protected by the wage payment law, the wage and hour law, and you pay into unemployment.
And so the person works for them for 3 days and then they're collecting unemployment because there's no job the next week?
Justice, to be candid with you, the standard for whether you work for 3 days, whether you get unemployment, I don't believe you'd be eligible for unemployment after only 3 days. So in that case, I
don't know the answer to that.
But you read Section B the way Mr. Hamner does, or do you read it differently?
I read it a little bit differently because it says or. So if you meet the first part of B, you meet B. It doesn't say you have to meet both parts.
With regard to the second part, if Joe Smith LLC works for different installing companies throughout the year, and only works for East Bay 1 day a month, is that LLC considered an employee of East Bay? I hope I've said that right.
I had a little bit of trouble following it, but you're saying that as I understood the question, if you work for multiple places during the year or during a month, yes. If you're working for multiple places, there are people who get multiple W-2s at the end of the year for how much they worked at a given place.
So you read it as Mr. Hamner does. If you've worked for them once or twice or only 10 times for the entirety of the year, you're treated as an employee for those limited jobs that you completed.
If you meet the standard, the facts you're giving me you'd have to apply them to the ABC test, because if you're performing the services, if you're talking about the second prong, is it performed outside all the places of the business of the enterprise? I think that's the part it seems like we're struggling with. There's consequence to both sides. Because right now, if you say, well, we're just going to limit to the four corners of an office, that's going to lead to widespread abuse, and that's what we're concerned about at Neal, New Jersey.
But if the work site is the office, then the answer to the question is yes?
If the work site is the office, if the work site is, with the way the cases have come down in New Jersey, the way the state courts, the federal courts, and cases across the country have come down on this, they've all been pretty clear that if you're assigned, if you're working out of a place, and if East Bay Drywall works out of their house, or they have a Regis space or whatever it is, and they're there and they're assigning people to go out into the world to represent their interests and to do an assignment, then that's part of what the employer does. I handle a lot of truck driver cases, and you have cases where people show up to a warehouse in the morning. They're given a list of places to go, and they're told, here's the times you have to get here by. You need to call us during the day. And then they spend an hour or 2 hours loading their truck, getting their instructions, and then they go out they go out to make their deliveries.
And if for whatever reason that truck driver chooses to work for you 1 day a month and has many others for whom the person works on the other days, they're an employee for those 12 days?
There are plenty, Your Honor, in union halls, people, yes, the answer would be yes, because in union halls and other places, this happens, where people come in, they're told, hey, we need you today, you come in, and then for that day, instead of getting a 1099, you get a W-2. Now, candidly, I don't see a lot of times where someone's only working 1 day a month in that kind of setting. People are usually there, and this is where the abuse happens. This is what we're seeing in the cases, and this is why I want to bring it up to you, because this is the consequence of what's happening here, where you misclassify somebody. The problem isn't when someone works 1 day a month, it's when they're working 75 hours a week, and they're not getting any overtime, and their employers or their non-employers.
Do you see the issue that we have here? Because if this stands or falls under B and locations, there is no distinction between the person who's there and the chief's hypothetical 1 day a month and somebody who works, 7 days a week.
But I think in terms of I think it's perhaps an error to focus on the frequency of how often they're coming into work as opposed to what they're doing when they're working. So my daughter just got a job this last weekend, and until school ends, she's working 1 day a week. So that happens to be what her schedule is. For that 1 day when she's there, she's an employee. So if you're...
But I don't want to discuss your daughters. I understand it's on your mind, but I mean, realistically, you could have somebody working for 50 different contractors in an area in which there's a lot of construction. The person could be in the course of a year working for 50 different contractors, technically, right? And they are and what you're asking, what the Attorney General and you are asking the court to do is to essentially say that there's no floor to this. They're employees of everybody, every contractor they work for. You see the issue.
I do see the issue, and I do see what you're struggling with, but I think the consequence of what you're saying is then these people will be employed.
Well,
we have two alternatives here. They get a 1099 or they get a W-2.
What I'm saying is forget what consequences of what I'm saying. I'm asking a question.
Yeah.
And trying to ask you to help us as amicus with what I think is a test that is being urged on us based on location of places that really kind of create the subcontractor, unless it's a big business, no longer is an independent contractor under this scenario.
Well, under this term subcontractor, under the Wage Theft Act that was just passed, if there's joint and several liability for violations if you provide labor to someone. So that distinction isn't as important in the law anymore, given what the Wage Theft Act says about them being joint and severally liable.
Right, but we're talking here about the unemployment compensation law.
Correct.
Right? So you could have somebody having 50 employers in the course of a year. Is that really what the legislature was thinking?
I don't know if the legislature was thinking about 50 different employers. I think what the legislature was thinking is, if under the law, if you're providing services somewhere, you receive certain protections, and those protections come as an employee because we want you to be considered an employee because you receive certain protections under the law. So, for your example, when someone works 1 day a week, during that 1 day a week, there's a lot of abuse that can happen.
I guess we can't engage in sweeping generalization. We shouldn't, because the example that you gave, someone working out of a union hall, if they went to 50 different places, they would have employment in 50 different. They're not an independent contractor.
Correct.
People who are working out of a union hall.
Correct.
That doesn't necessarily sweep into this. Now, I got a question about B. Did you say that there's light between you and your co-counsel on B?
I don't know if there's light between us. I